Comincio con il ringraziare gli organizzatori italiani, and then I will continue by saying thank you to the team of the Center for Judicial Cooperation in cooperation with the Italian School for the Judiciary. Gianandrea mentioned before that I'm at home here myself, but I'm also at home with both institutions, the Italian School for the Judiciary and also the Center for Judicial Cooperation, to the foundation of which Betka in the beginning of the year 2000, I have a privilege to participate with Professor Azola. Thanks also to Valeria and other colleagues who are here, who are over the years being a reference point for the topic that we are going to cover. In particular, I would like to mention that there is one piece, one document of the Consultative Council of European Judges, which is due also to the commitment of Valeria and Marc de Verde, who will be one of the other speakers during these days, which is a very relevant topic in the area, especially of freedom of expression. So something that Professor Almay has already mentioned. Having Professor Almay as a chair and the fact that he mentioned the crisis of the rule of law in some countries will provide some further background to the little discussion that I wish to initiate. My presentation is on the program as being a sort of keynote speech, but I would prefer to downgrade it to a regular conversation, maybe subdividing the time we have between some 30 minutes of my presentation and maybe 15 minutes of your interventions and or question and answers, as Professor Almay will coordinate. The idea I would start with does not refer to the rule of law crisis and the relationship between discipline and maybe restrictions on freedom of expression of judges, but will rather go to the core of what has happened over the past few years at all levels. In neoliberal societies, we have assisted to this trend, which has for sure drawbacks for judicial independence, toward saying that liability of judges in general, so civil, criminal, disciplinary, is one of the several tools to ensure accountability of the system as a whole and of the justice system in particular. If we only go to the EU Council conclusion of 2021, just to restrict our view to the European Union, we see that, for example, on the one hand, there is a favor on dialogue between judges, which, at first sight could be considered a very positive element. On the other hand, you have a strong support and endorsement to those policies that see that monitoring, transparency of the justice system, but also personal liability of judges should be something to improve and or realize. The second element of this wide picture is that at that point, especially European courts, but also some national superior courts, have been called to find a new balancing between those conflicting values. So on the one hand, we have a need to increase accountability and therefore work on discipline, civil liability, criminal liability of judges. On the other hand, let's not throw everything away that we have built over the past few years in supporting judicial independence as a fundamental element on the rule of law based on separation of. I will only talk about the case law of my court. That is the task that has been given to me. But of course, many parallel considerations could be developed concerning the Luxembourg court case law. I will make available, and anyway, we have the link here to a fact sheet that my court has posed and proposes regularly over time, updating it from time to time on judicial independence. So you will find under the heading of judicial independence also topics that cover disciplinary liability. The rule that we have in European Convention is, of course, Article 6. Which provides for an independent and impartial tribunal. And there is no need to have there any mention of what is the role of disciplinary liability for judges, because when you want to have at the same time independence and impartiality, some liability, some controls, some checks and balances are, of course, needed. Therefore, it's for the case law to develop principles in this area. Everyone, citizens, the justice users, is entitled, therefore, on one side you have the court, on the other side you have everyone who is entitled to a fair hearing, which involves that the hearing can also be unfair for responsibilities that can be of an organizational reason, but also for individual reasons. And then there is within a reasonable time, which of course puts the emphasis on organization by an independent and impartial tribunal. On this topic, independent and impartial tribunal, the recent case law has concentrated a lot. I will try to cover this in a moment. The real piecemeal that I would like to serve you today is this little scheme, which is very basic, and I tried to do some empirical work, just making a list of those topics that you will find as being covered by our case law. So what are the independence criteria? What is the what are the real keys to statutory independence? That means that the law, the legislation has to provide for independence of judges. Then there is a so-called doctrine of appearance. You know this very well. Judges not only must be independent and impartial, but also should look like being on the basis of appearances. And then the relationship between Article 6 and other convention rights. And finally, we come to disciplinary proceedings. My experiment has been seeing what happened between 1970, more or less, and 2020. Professor Almay has mentioned that over the past few years, we've had this rule of law crisis. So before this happened, we had a progressive building of case law on those areas that occasionally concern also disciplinary proceedings, but when they do, it's because security of tenure and the nature of disciplinary proceedings had come to the attention of the court. I'm citing here some very, very famous cases. One of them has also been in the Luxembourg court. Baca, former president of the Hungarian Supreme Court, whom most of you will have heard of. And the other two cases, Alexander Olkov and Denisov, both cases against Ukraine, which concern disciplinary proceedings against them. We will go into that maybe in a moment. But so, the idea is that the conflict between rules about discipline and independence was not something that needed to be caught in those years. Then, over the past few years, basically in 2 years, because then what happens after 2022, it's a matter of today, and I will cover it separately, is that all of a sudden, disciplinary proceedings come to be assessed by my court under the heading of the independence criteria, especially under the heading of the tribunal established by law and the fact that the High Councils for Justice, namely the Polish High Council for Justice, most of the case law concerned Poland, was politically influenced and made appointment of judges, including chief justices in several courts, which kept into account more political considerations than the merits and seniority, the latter being the criteria that should preside over appointment of judges. Therefore, we came to develop a case law concerning especially the tribunal established by law, meaning that when you have judges that are targeted by way of disciplinary proceedings, that you have a body aimed at protecting judicial independence who is, on the contrary, politically biased, then the concept of tribunal established by law, unfortunately, collapses, and we have found violations, a number of violations. We can skip the whole body of soft law information, including the one that I mentioned a moment ago of consultative, of documents issuing from the Consultative Council of European Judges, but what is sure is that the sources that my court had available when this case law between 2020 and 2022 had to come to life was a body of soft law. So no previous case law, no other references, something in Luxembourg, of course, but most of it was soft. I will now start very, very quickly a sort of listing of what, in my personal opinion, because the list would be very long otherwise, are some relevant cases for your attention. I will not start from this, it's not a chronological listing, it's a listing by subject matter, and there is a sort of criterion showing you separate challenges that I see in dealing with disciplinary proceedings. The first challenge comes from one type of procedure that some of you might be familiar with, some of you might not be familiar with, which is the so-called vetting procedure in new democracies. again, I'm saying vetting in new democracy. Both things going together, because many countries have vetting procedures that is review over time on a periodical basis of professionalism and especially integrity of judges. In my country, in Italy, for example, we have a 4-year assessment by the High Council for the Judiciary of the results reached in the previous 4 years. And this gives you occasionally also pay increase. So there is a judicial career, but there is vetting in new democracies that has different purposes. And that is especially in when there is a transitional arrangement for justice to subdivide those judges that might disclose an appearance of being questionable because of relationships with previous political regimes and or participation in anti-democratic activities, in taking them away, not necessarily on a fault basis, but on the basis of protection of the general image and prestige of the judiciary, taking them away from the judicial core. Now, there was this case, Shoshai versus Albania, which is fairly recent, and the court has held that there was no violation of Article 6 of the Convention as to the composition and functioning of this independent vetting commission, although there were some drawbacks. So basically, if we like to transfer this case law to discipline, there is a need that the body in charge of discipline should be independent. But my assumption, and that's why I have this case presented to you as the first one, is that vetting procedures are not disciplinary procedures. So even if you will find in this judgment and elsewhere some usage of the adjective disciplinary, please consider that if we are talking of discipline, we are talking of a very peculiar notion of discipline, because it may well be that the judge has not done anything during the exercise of the function, but usually what is vetted, what is assessed, is what happened before the judge became a judge. And possible, in other countries, you have so-called lustration procedures. Let's come to a second topic, which I would call targeting of judges. You say, no, we are talking about disciplinary proceedings. What is this targeting? And the caution that I would issue for your attention is that disciplinary proceedings have been used in Europe, have been used as a way of targeting judges, in the sense that the scope and aim of disciplinary proceedings, that is improving the quality of the judiciary, is used instead to get rid of a judge who is of a certain political view, or who is not in conformity with the majority's approach in that specific moment. The main case that we have dating back to 2022, so this ideally concludes the evolution of the case law that I was proposing to you to analyze, is Jurek versus Poland. Mr. Jurek, being a very prominent judge who made several declarations in his position as the porte-parole, the spokesperson for the National Council for the Judiciary, and National Councils which afterward changed in its composition and political outlook. Basically, he was one of the many critics of the system. He was, in a way, a defender of rights, and he was submitted to a number of tax inspections, to some disciplinary proceedings, and a number of other, especially tax approaches that he viewed as being a sort of persecution or target. We found a violation of Article 6 and also of Article 10. The violation of Article 6 is very similar to any other violations, and it relates to the fact that there was a breach of his right of access to court in order to be protected for the fact that he lost his job and there was no real judicial instance to which he could bring his claim. This has been also done by the court in the case of Grenda versus Poland, which is a Grand Chamber case concerning the fact that the High Council for Justice of Poland was dissolved by way of law. And so this judge, Mr. Grenda, who had been elected, saw his mandate terminated ahead of time. Something similar to Baca in a way. But anyway, Jurek is also very important because one of the topics at stake was the fact that Mr. Jurek was talking with the press and was exercising his freedom of expression. I will have to skip a few topics, but basically Broda and Boyara is the fact that, like Grgenda, in Grgenda it was the mandate as a member of the High Council, which was terminated by law. The two ladies, Mrs. Broda and Mrs. Boyara, saw their termination as vice presidents of the courts. So basically, they restarted to appoint vice presidents, and although their mandate had not finished, they had to return to their regular task as judge. Baca versus Hungary had the component of freedom of expression, because also Mr. Baca was making statements, and he saw his role as president of the Supreme Court of Hungary. We are now going back to the old time. You remember Baca was in the first time slot of my presentation. The idea is also that you can have absconded or indirect way of disciplining judges by not promoting them or by not granting extension of their mandates. For example, in a system like in Poland, in which at some age you could ask for an extension after having had a medical check of your health and have an extension and stay in service for another couple of years, well, these people were not granted that extension, and there was a very strong presumption that this was done for political reasons. So this is not discipline as such, but it was a lack of renovation in the function. This is probably the grand case concerning disciplinary proceedings. It does not concern a rule of law crisis environment because it concerns Portugal. But this case, Ramos Núñez de Carvalho gives the general picture of what the relationship should be between judges, the disciplinary body, the composition of the disciplinary body, and the requirement of independence and impartiality of those bodies that are responsible for discipline. Here, no breach was found and no violation was found, as the Judicial Division of the High Council for the Judiciary of Portugal was found to be in compliant with general requirements. Now let's finish. I will only use 5 more minutes, and I will give the floor to you with what are the topics, and this was my, so to say, final scheme that can give rise legitimately to disciplinary proceedings. Of course, we will see this from the opposite, because we are going through the case law of the European Court of Human Rights. Therefore, we will find those things that should not be the object of discipline. And one thing is, for example, private life. So in this case, Ozpinar versus Turkey, an old case of about 15 years ago, we have a lady judge who is criticized because of her very private life, relationships with men, too many men, and her appearance and other rather disturbing elements like those. And they were found domestically in Turkey to be in conflict with her role as a judge. The European Court found a violation. Okay, I will not get into it. Miroslava Todorova is a Bulgarian case which addresses the area of delays on the job. And of course, delays on the job can be a legitimate basis for disciplinary proceedings, although, as we know very well in my own country, usually delays result from a mix of elements: the role of the chief judge, the organization of the court, the attitude of lawyers, the amount of general work that the judge has to do, etc. But in this case of Ms. Todorova, there was a mix of violation and no violation, in the sense that this dismissal based on delays was then changed into a 2-year suspension for the TOST. And this case is also linked with freedom of expression. So please have a look. We finish by considering a bit global society, internet, Facebook, etc. Should disciplinary proceedings concern this area of activities? Kozan versus Turkey concerns a reprimand imposed on the applicant for having shared on Facebook, in a private Facebook group. This is also very important. A press article headed "Judicial Rehabilitation for Closing the 17 December Investigation," etc. So news concerning what happened in the judiciary, merely shared on Facebook without posting any comment or adding any like. Violation of Article 10, but also violation of Article 13, because the judge had no way to bring a claim before court. TRIIAL versus Poland, I will not dwell on this, although it's a very important case, because it's very, very similar to Jurek. In TRIIAL, however, you have targeting of this judge, who was also a strong opposer of the Polish regime, because he made an oral presentation of the reasons behind the decision and he was accused of violating secrecy of investigation. Also, there were some other charges concerning his declaration in public, which led to 5 sets of criminal investigations. And in the end, the targeting was done not by way only of disciplinary proceedings, but also by lifting criminal immunity to which Polish judges are entitled. We are not. But so there is also a concentration of the court in this case on the way to use criminal liability as an indirect way to target a judge, to discipline him, to intimidate him or her in the end. And I finish with the hot part of this meal with the very prudent clarification on my side that I will not say anything on this case. It's called Daniele versus Romania, because the case is not final, and because a request for referral to the Grand Chamber is pending. Therefore, I could be in this case, and I will not comment on it. But you see that it deals with a posting of 2 posts on Facebook by the judge with very strong declarations in these posts. According to the judgment, you will be able to read in the judgment what the post contained, but there was in the first message a questioning the credibility of public institutions and the fact that the only solution would be that the army should take power to guarantee constitutional democracy. And in the second post, there was a hyperlink to a press article and a comment praising the courage of the prosecutor who had spoken openly about the release of certain prisoners. The court in a chamber has been split into 2 groups, 4-3. There are very strong separate opinions. So my only comment is, please go and have a look, and let's wait whether or not it will go to Grand Chamber. I would stop here, and I would again thank for the invitation. I'm available for discussion and to listen to possible interventions.